So for today's session, is to provide you with the employment law, including relevant legislation and case law concerning the rights and obligations of employers and employees in Singapore. So this session is also to address the common disputes related to the Employment Act, employment contracts, as well as and employer and employee disputes, employer and employee relationships. And finally, it will also cover available dispute settlements and forums, mechanisms to resolve employment conflicts in Singapore. So a little bit more about our speaker today, Mr. Shaun. So Mr. Shaun Lee is actually a dispute resolution partner at Bird in Singapore. He specialized in high-value transactional commercial disputes across sectors like TMT, finance, and infrastructure. So with extensive experience in both contentious and non-contentious employment matters. He was also previously the lead associate for a top-ranked employment team. He's a dual qualified lawyer in Singapore as well as England and Wales. He acted as a lead counsel in courts, mediation, regulatory tribunals, and international arbitration. So in 2019, he has been recognized for his expertise in commercial litigation and international dispute resolution. So without further ado, I would like to pass this room to Mr. Shaun for his sharing session. Okay.
Right. So good evening, everyone. Thank you so much for your time today. I think the introduction has already been made, but very briefly, my name is Shaun Lee. I'm a partner with the law firm Bird & Bird ATME, the Singapore office of the network Bird & Bird. And as described, I am a disputes lawyer. So a lot of what we're going to be talking about today is going to be it's going to be about employment law from the lens of dispute resolution. Okay, and the reason why I want to talk about it is because I think it identifies what are the common issues, problems, and what I call the flashpoints in employment disputes. So I'm the type of lawyer that actually goes to court. I'm not the kind of lawyer that basically just does drafting and negotiations. I actually have to advise and represent parties in court or before regulatory or before tribunals like employment claims tribunals for these kind of disputes. So I know what it's like, I know what the issues are, I know where the fights are, and I know why certain things are more problematic than others. A lot of what I'll be talking about today can be found online. I don't dispute that. So I want to move away from what you can find online to what are the main and major issues that you generally face, whether as an employer or as an employee in Singapore. I will try as far as possible to talk about the law. So there will be points that will be perhaps slightly more employee-centric, but there will also be points that are perhaps slightly more employer-centric. The two final things I wanted to say, one, there's a version of this slides, a revised version, to update some things that have been talked about regarding the new shared parental leave regime will be provided to you through PPIS after this presentation. So don't feel obliged to have to take down notes or to take photos of the slides. Don't worry about it. It will be provided to you. Second thing is I'm aware that the Q&A session is 30 minutes, but don't worry. If PPIS are happy to keep the doors open for a little while longer, I'm also very happy to stay back to address any further questions you may have, whether on the presentation slides or on specific issues that you'd like to raise in today's talk. So there are four things today that I wanted to discuss. First is, what is the Employment Act? What is the relevance of the Employment Act to both employers and employees in Singapore? Second, the key employment terms. What are these key employment terms and why are they important or potentially important to you? Third, employment contract disputes. These are the things that we see most often, the ones that clients come to us, whether or not I'm acting for the employer or I'm acting for the employee. These are the most common disputes that I see. And finally, what to do when things go wrong. So one of the interesting things that because of what I do in the courts or with the ministries, there are certain things that I feel are more effective that you may not be aware of unless you've been through this situation before. Finally, of course, we'll close off for the Q&A session. So what is the Employment Act 1968? And before I go before I go on to the Employment Act, or the EA for short, I want to very quickly draw, first and foremost, a distinction between employees and freelancers, or what we call independent contractors. Okay, this is very crucial. This is very crucial. If you are providing services, okay, you're either doing it in one of two ways. One, you're an employee of the firm. Two, you are a freelancer or independent contractor providing services to that particular company. So an independent contractor is not an employee. Why is this significant? Because an employee's rights and obligations are governed not just by their employment contract, but also the terms in the Employment Act. If you are an independent contractor, your rights and obligations are entirely defined by your contract with the company. Okay, the Employment Act does not apply if you are a employment independent contractor. If you're an employee, the EA applies. These are some of the general features, distinctions to be drawn between freelancers and employees. I don't intend to go into that now, but generally speaking, what you'll find in your contracts is that it will probably describe you as an employee. There are certain employers, certain firms that may try to classify you as an independent contractor. However, the courts and the Ministry of Manpower take what we call a substance over form approach. You can call it whatever you want, but if in substance, if in effect, if in reality, you are an employee and not an independent contractor, it doesn't matter if you're called a consultant, it doesn't matter if you're called independent contractor, it doesn't matter if you're called a freelancer, you are still an employee of the firm, and therefore your rights and obligations that are under the Employment Act. So what is the EA? It is Singapore's main labor law. It sets out an employee's rights, entitlements, and obligations. I should point out the EA is not super duper comprehensive. The EA, for example, does not tell you what your salary is. It tells you when you have to be paid. It tells you, certain things, but it's not the end all and be all. But it does set out your basic rights and obligations. Why do I say that? It's because it sets out the minimum standards. An employment contract cannot fall below these minimum standards in the EA. If it does, that provision is invalid and unenforceable. So for example, you cannot have less than X number of days of leave. So I will go into that, don't worry about it, but it's worth bearing in mind. The EA makes it very clear. If your employment contract provides you with less than what the EA provides you, that is not valid. It's void and unenforceable. So I just want to go in a bit of history here. Once upon a time, right, it was actually quite easy to give these kind of talks because most of us would not be covered by the EA. Okay, because once upon a time, the coverage of the EA was very narrow. It basically applied to essentially foreign work, basically work pass holders, your SP, your special pass holders. It didn't quite apply to the vast majority, a good chunk of local Singaporean workers. So now, however, everyone is covered. Since 2019, everyone is covered. Okay, except again, and I don't think this applies to anybody here. Seafarers, domestic workers, and your state board or civil servants. So it is now relevant. I can talk about it. I need to talk about it because it actually applies to all of us, regardless of whether you are a PMET or whether or not you are in other fields. Okay, how do you understand the key parts of the EA? Now, the key part of the EA, okay, the most of the time under the Employment Act, what is the most relevant is what we call Part 4 of the EA. Part 4 of the EA deals with issues like rest days, hours of work. But I would stress this, okay, it may or may not apply to all of us here. It only applies to Part 4 protections only apply to two types of employees. One, a workman earning a basic monthly salary of not more than 4,500, or an employee who is not a workman and earns a monthly basic salary of not more than $2,600. So again, the EA applies to everybody, but in terms of your protections, OT, rest days, that is covered by Part 4, and it still doesn't apply to quite a number of, well, it doesn't apply to managers and executives now. Okay, so there is that to consider. So I want to speak very quickly about key employment terms. And the reason why key employment terms are so important is because these are the minimum terms that must be provided to all of us as an employee of a firm. All right. So it can be provided in various ways. It can be written, it can be electronic, it can be accessible online. But the thing about it is that this is mandated by MON. Now, why is it important to have these key terms available in written or electronic form? And the key reason is because prior to this, there was a lot of abuse. Okay, there was unfortunately a lot of abuse regarding promises that were made by employers but not kept by employers. I'm not going to pretend that not going to pretend that everything is perfect, but having these key employment terms is more helpful than not in ensuring that employees are aware of their basic rights and obligations, right? Your title, your salary, your rest days, number of days of leave. These are part of what we call the key employment terms. So these are basically the 19 things that you need to provide to all employees at a very minimum. I don't intend to go into it, but you can see why it's important because it makes it very clear to you what, at the very least, the very basic stuff that you really should know. You really should know or should be entitled to know, and to ensure that employers don't try. Let me be a bit more careful with words. And to ensure that employers don't try to circumvent these obligations. Okay, let's just read it. All right. The next few slides I do want to go over fairly quickly because a lot of it is available online, and a lot of it is I think very readily available on MOM's very excellent website. Okay, so things like salary. I mean, yes, you must be paid at least once a month. You must be paid within 7 days of the salary period. I think what I want to mention is the last point. You cannot waive your CPF. Okay, if you're entitled to CPF, and all employees are generally entitled to CPF, you cannot waive the CPF. You cannot be asked to pay back. Again, I'm not going to say that there's no abuse of the process, but just be aware that your legal rights and entitlements includes no waiver of CPF. If you are wondering, let me see if this works. No, pointer. Oops. Yeah. Oh, I can't show the screen. If you're wondering why it needs to be in Singapore currency, or more specifically legal tender, what happened was there was this very abusive practice that developed primarily in America, but also in Western Europe, whereby employees were paid in company scrip. What does this mean? Company scrip is basically a company's own currency, and you could only use that to buy from a company store. But of course, the company is just going to inflate the prices like crazy. So this is why you have this article provision there. Reforms are made. Again, I stress, reforms are made in the UK, reforms are made in the US. But this is why, if you're wondering why this specific provision is there, that is the historical reason. Okay, not to say that they can't give you points, okay, on top of your salary. I know that some companies do this to promote health and wellness, for example, and you can basically accumulate points and redeem it for various things. But that's perfectly fine. But your salary cannot be paid through those points. Yeah. Okay. You are allowed. Sorry, your employer is allowed to deduct from your salary. But I want to stress a few things. Okay, I want to stress a few things. There is a limit to what you can deduct for, and how much you can deduct. Okay, so for example, the very last one doesn't work. The very last point, your deductions for approved, and I stress again, your deductions can only be for approved categories, like what? CPF, like what? Absence of work, or if you damage stuff. But again, very, very clearly, you cannot deduct more than 50% of your monthly salary. The employer cannot deduct it. So it is very important that where if there's deductions, it doesn't exceed 50% and it's only for approved deductions. The other thing I wanted to point out as well is this. If you look at the third last bullet point from the bottom, there are certain things that you can't deduct for. So for example, I'll talk about this, okay? Something called LDs, liquidated damages clauses. Basically what happens is sometimes you're finding employment contracts, they will say if you breach your employment contract, you leave early, whatever, you have to pay X amount. Okay, and the X amount is what we call a liquidated damages clause. They can't deduct it from the salary. And I will also talk about it subsequently. LD clauses are very, very rigorously enforced in Singapore. What we do find is that a lot of employers do not understand how LD clauses work, and therefore a number of these LD clauses, a lot, are not enforceable. Okay. So for the benefit of those who have just joined us, don't worry about it. These slides or a version of these slides will be provided to you after the talk. So you don't have to feel the need to take down all of these things. So don't worry about it. Okay, working hours. Again, I should point out things like for things like salary that is actually applies to everybody. Okay, applies to everybody. It's not just to part 4. But working hours, I will stress, only applies to employees who fall within part 4 of the Employment Act. So what this does is that requires that there must be break times. It requires that you can only work up to certain hours of certain number of working hours a day. I have seen must watch my words. I've seen very, very egregious abuses of this, okay? I've seen very horrifically egregious abuses of this, particularly when it comes to what I would very loosely call service providers or manual workers, okay? I one egregious case where the employer basically says this guy who is hired to clean the estate, so basically the person who is attached to an apartment, he basically was required to work 12 hours a day, 7 days a week, complete violation. And the employer, who claims to have a master's in law and human resources and stuff like that, had the temerity to argue that's perfectly fine. Okay. I will tell you a bit more about the particular situation because I think it's quite interesting as to what happened, and also because I think I can maybe share a little bit about what the government may be thinking of doing in these kind of cases. You can't do more than 72 hours of OT a day, but again, I stress a lot of these things only apply to part 4 workers, so it may or may not apply to you. If you do OT, you are entitled to 1.5 times your hourly rate. All of this, by the way, should be in your KET, your key employment terms. What is your hourly rate? What is your overtime rate? Stuff like that. And remember, assuming this applies to you, the Employment Act sets a minimum standard. So for example, they say that OT is only 1 time, it's at the same rate as hourly rate. No. Okay, 1.2 times also no. Okay, so bear that in mind. Rest days, again, I think quite a number of us in the audience today don't fall within part 4, so all of this is irrelevant. I work pretty much every weekend. I don't get compensated for it, but that is life. I will point out, and it's here. Okay, no. Very often, and I hope this is the case, most firms would, if you're working on a rest day, most firms would do provide off and due. But strictly speaking, if you're not covered by part 4, OT is irrelevant. Rest days are irrelevant. Payment for rest days is also irrelevant. Yes, Singapore has, again, I think I probably have to say this, don't I? Singapore has tried to find a balance regarding pro-employer, pro-employee schemes, and I think it's basically a policy in evolution. this is basically a matrix that is shown regarding what happens if you work on a rest day. It is, of course, possible to be provided with a day off in lieu. But if you are part-time, if you are a shift worker, right, you can't just be given time off. You must be paid on your rest day. But again, you need to be a part-4 worker. All right, annual leave. Now, here's the thing. You would see here that this is the minimum amount of leave that you are required to be provided. Again, not part 4, but this is the amount of leave that you're required to be provided under the Employment Act. I think to be honest, I've not seen any firm offer less than 7 days for your first year. I think generally speaking, we are looking, most firms exceed 14 days. But I should point out, assuming that, again, companies can provide the bare minimum. And the bare minimum is, in your first year of service, is 7 days and increases to 14 days thereafter. This slide also talks a little bit about encashment of leave and forfeiting of leave in certain circumstances. Again, that's on the slide, so feel free to take a look at it. Yeah, I mean, again, these are very special situations. So for example, these are real life examples, of course. Let's just say that it's the eve of Hari Raya, eve of Chinese New Year. Firm declares half day off. You want to take the rest of the half day. Does it count as half day or full day? The law actually says it's a full day, or rather the company can say it's actually a full day and not just half day. So amazingly enough, it's actually covered by the law, even in these kind of special situations. You are entitled to carry forward your leave under law, but up to a maximum of 14 days. Well, yes. But again, the carrying forward of leave only protects those who are part 4 workers. Again, I don't want to go into much detail, but these are basically the kind of situations you'll face if there's an issue regarding having to work on public holiday and what are your entitlements, so off in lieu, another working day, stuff like that. Again, special situations. These are rare, but these are basically catered for. A lot of this is found on the MOM website, so I don't intend to go into too much detail. So sick leave and hospitalization leave, again, these are your statutory minimums. And what I do find is that unlike personal leave, annual leave, most firms provide the minimum. Okay, I think for whatever reason, while firms are generally happy to give more than the statutory minimum of annual leave, you will find that very often the amount of leave that you get for sick leave and hospitalization leave is the minimum. Okay, there are certain things that I think is worth noting. One, if you look at this particular scenario, this is a very strange scenario. How much leave are you entitled to if you have just started working with a particular firm? So if you've worked with a firm for more than 6 months, I don't think you have to worry about this particular slide, right? But it is worth noting that under law, you are actually required to. You have 48 hours from the start of a medical leave to inform your employer. I'm just putting it out there because this is what the law provides for, but obviously do take guidance from your internal policies. There are good reasons why you would want to inform your employer before you take leave, before you potentially are given medical leave, or right as soon as possible once you have medical leave. Okay, this slide, okay. The revised slide which I provide to you will have the revised updated version for now until at least 1st April 2025 and then 1st April 2026. This is the minimum. What is the minimum? 16 weeks government paid maternity leave of the particular cap. Okay, 16 weeks. You can share 4 weeks with your husband or the father of the child, but that 4 weeks is taken from 16 weeks. Okay, so that basically creates a bit of it's not great. So what has happened? Well, there has been a change, and I'll talk about this even though I don't have the slides. What has happened is that starting from 1st April 2025, you get 16 weeks. The father will get 4 weeks, mandatory. Okay, no more from the 16 weeks. And on top of that, you get 6 weeks of shared parental leave. Okay, again, is this commensurate with other parts of the world? No, but it's not too bad. I mean, there are worse places like the US. I go back to the US because some of their labor laws are quite extreme. But if you look, for example, at Europe, you'll find or Scandinavian countries, you'll find very extensive maternity leaves. Now, I'm not going to deny it's going to put a lot of pressure. I can kind of feel it because technically I'm a partner, so that I am self-employed, at least in the eyes of IRAS. And I do have to manage a team. And I just last year, one of my senior associates went on paternity leave. And that was rough. And that was only 4 weeks, by the way. That's only 4 weeks. He didn't even take the 4 weeks, just took 2. And that was already a big problem. So, big problem, I stress again, in a non-pejorative sense of the word, a problem only because the way that we are structured isn't quite dealing. I mean, the onus is ultimately on us as the employers to deal with these matters. Of course, we dealt with it. We basically tried to find cover and stuff like that, but it was rough because I think, yes, it is what it is. So certain other parental-related leave, there is, by the way, adoption leave. If you decide to adopt, you get 12 weeks to be taken within 12 months of the adopted child's birth. There is childcare leave. You have 6 days per year for each spouse, and basically capped at 42 days all in. So 6 days per year until the youngest child hits 7 years of age. The paternity leave and the shared leave thing is, again, I think this is basically what the current position is, but it will change very soon on 1st April 2024. Okay. Now, this is important. Termination of employment. If you want to resign, or if the employer wishes to stop or fire a particular employee. There are 2 ways in which this can be done. 1, you give written notice. Okay, you must give written notice, and you must either serve out the notice period. It can be. You will see again. What you see there is basically what the Employment Act requires. If you are working, again, all subject, I stress, all subject to what is in your employment contract. But this is the bare minimum. If you have worked with a firm for less than 6 months or half a year, it is 1 day notice period. If you have worked for 26 weeks to 2 years, it is 1 week. 2 years to less than 5 years is 2 weeks. 5 years or more, you are entitled to 4 weeks of notice. Now, obviously, generally speaking, what you'll find is that for most cases, your notice period is going to be at least 1 month. It is very rare, except in probations, where you have a shorter notice period of 1 to 2 weeks. Generally speaking, you're looking at 1, 2, 3, and possibly even 6 months for very senior lawyers. Sorry, very senior executives, my apologies, very senior executives, 6 months. I have seen 12 months as well. But part of the reason is because, I'll talk about this, something called garden leave, where you basically pay a person not to work. And the idea is to basically ensure that they don't join a competitor. All right. So I want to stress this again. If you are required to work during the notice period, but you can basically truncate that notice period. You can shorten it. How? You pay. Employer pays you, or you pay employee, or you pay the employer. So basically, you can theoretically leave tomorrow if you're willing to pay the entirety of your notice period. Notice, of course, this is all contract, right? So let's just say that you have a 3-month notice period. Can you shorten it? Yes, you can shorten it by agreement. If both parties agree, you can, of course, bridge your notice to 1 month or less. I would say this, it would be best to negotiate this. Of course, you are fully entitled to insist. Let's just say that the company wants to abridge, but you're like, I just want the money instead. You can. I'll say, okay, you can. The third point is actually very important, but I want to be there's a reason why it's highlighted in yellow and in bold. If there has been a material breach of your employment contract, you are entitled to leave immediately. The risk, however, is this. Okay, you always run the risk that a court may say that was not a material breach of contract. So that creates problems. All right. So the examples which the MOM has specifically identified as material breaches, if you've been failed, if your salary has not been paid within 7 days of when it's due, if you feel you've been asked to do something that will involve danger, violence, or disease, which is not stated in your contract. If you are a doctor or nurse, obviously that's going to be very different. But if you are a office administration staff, a manager, and you're suddenly asked to go into hypothetically, basically remember COVID, you're asked to travel to a place which is like at the epicenter, wherever the Italian city was, or Wuhan, as the case may be, that may be grounds to say that's a material breach. I did not agree to do this. This is a breach of contract. I better leave. But I would suggest please seek advice from either MOM or a lawyer before you decide on this course of action, because it is quite drastic. Okay? Another question that we tend to see is what happens if your employer or if the employer says, I want to change the contract. I want to change terms of contract. And you will find in your employment contract or in your guide or your handbook, sometimes you'll have this provision which says the employer is entitled to change what we call unilaterally, own self change the terms and conditions of the contract. Here's the thing, you don't have to accept it. You don't have to accept it. But the employer is also justified in saying, okay, you don't accept it, I give you notice. So again, these are things that really should be discussed, worked out, negotiated, and worked out as far as possible. There's also an argument if you basically were told of this change in the terms and conditions of the contract, and you don't say anything. You just continue working. That I stress again, may be a deemed acceptance or an acquiescence change. So you can't say, oh, I didn't agree to this change. All right. Next, let's talk a little bit about the difference between retrenchment and retirement, and why is it that this is important? I will say this. Okay, retrenchment. I will stress one thing: there is no automatic right to retrenchment benefits unless it's actually stated in your contract. There is a practice. Okay, I stress again. There is generally a practice that whenever there is a retrenchment exercise, you tend to be paid. Anything between 1 week to 1 month for every year of service. But that is entirely at the employer's discretion. They don't have to pay. You are entitled, but the law doesn't require them to actually pay you anything. It's a bit strange, but that is the position under Singapore law currently. Retirement, again, I should just want to mention that at least from until such time as they change the Retirement and Reemployment Act, you are entitled to you are entitled to be offered employment. But again, I will say this: most employers, I think, genuinely and generally try to make an effort, but there are ways in which you can structure it such that you are offering re-employment without falling afoul of knowing that it will not be accepted, or making it impossible to accept, and that should still fall within the law. Not great, but again, the law is not perfect. Ultimately, it's all down to human nature. And okay, I don't want to go to this too much, but basically, if you suffer workplace injury, your employer is responsible, and there are basically two ways in which this happens. You can either sue your employer in court, what we call common law, or you can claim through MOM under the Workplace Injury Compensation Act. And this particular table basically explains to you what the difference what the difference is. All right. So very quickly, some of this I already talked about already. Let's start first with employment notice period and resignation. I've had some very crazy cases where the employer just refuses to accept the resignation. Cannot. You can't. You can't be forced to work for somebody. Okay. People forget constitutionally we have prohibited slavery. We've also prohibited forced labor. NS is different because it's an exception. Okay. NS is constitutionally an exception to forced labor. Just saying. Okay. But you can't. So I've had these crazy situations where where employers just refuse to accept resignations. It doesn't work. It just doesn't work. All right. Yeah. The one thing I want to say, right, is the last one, the least burdensome obligation. Why is this important? If nothing else in this particular talk, I want to stress this. The law basically says if there is a breach of an employment contract, the damages that a company has to pay an employee is the least burdensome obligation. What is the least amount that they have to pay? Generally, invariably, unless it's a workplace injury, it's going to be your notice period. For better or worse, an employer or an employee is free to walk away. You're always free to give notice and to walk away. I have advised on cases whereby the employer feels like employee has done something wrong. Okay, egregious cases, suspected corruption, suspected embezzlement, but no real proof. Too difficult to prove it. You don't want to fight. So what do you do? Give notice, right? Give notice, because that is clean. Is that the best way of running a business? Sometimes it is, right? My role as a lawyer is to troubleshoot, to try to solve the dispute as efficiently as possible. I'm not denying the public policy issues, but for now, this is what the law only requires. So we've talked about this before. The first point is actually quite important. Very often in your employment contract, will say that the terms and conditions that your employment contract will also incorporate other terms, like for example, in a staff handbook. Those terms do apply as long as the staff handbook is accessible to you. Okay, as long as it's accessible to you, the terms and conditions in those staff handbooks forms part of your employment contract, right? I've talked about unilateral discretion. This is where I said you can theoretically just change anything, but the issue ultimately is you can be deemed to accept it, or the company can just basically give notice if the employer is not willing to accept it. Confidential information, another big thing that we always see. Employers will say, oh, they stole my confidential information. They set up a competing business. I want to stress a few things, okay? Company property, company information belongs to the company, right? It does not have to be marked confidential. Whatever it is on your company, whatever you do, whatever information you produce, access on your company property, i.e. laptops, PCs, company phones, belongs to your company, right? So be careful, okay? Be careful. Now, I stress again, I am not saying that, for example, your credit card number then belongs to the company. But what I'm saying is that except for some very specific personal information, or what we call sensitive personal information, health data, your credit card details, your financial information, everything else theoretically belongs to the company. And the obligation effectively becomes on the employer to prove that the information on the company property or use of the information is not a breach of confidentiality. Right. So as I said, in an employment context, the onus is on the employee. There are cases which kind of change this, which happened fairly recently in 2020. Oh, that was 4 years ago. Okay, relatively recently then. Okay. Another big one, non-compete clauses. Non-compete clauses, we all see it. Now, I will stress the second point. A non-compete clause, or what we call a restraint of trade clause, is prima facie unenforceable. You can't enforce it unless it is reasonable. But what is reasonable? we are looking at reasonableness on two prongs. One, is it reasonable? Okay, is it reasonable? Well, one, does it protect the employer's legitimate proprietary interests? What are these legitimate proprietary interests? Confidential information, stability of the workforce, their clients. Okay, the problem is this: if you have another clause, which says you cannot poach, you cannot solicit, and there's a confidentiality clause, then what point does a non-compete have? A non-compete is basically trying to stop somebody from earning livelihood. So that's a big problem. That's problem number one. Okay, is there a clause that already protects an employee's legitimate proprietary interests? Second, even if there were legitimate proprietary interests to be protected, the courts will still analyze the reasonableness on two further grounds. One, geographical scope. If you are working purely in Singapore, all your clients in Singapore, you don't even deal with any other part of the world, you try to basically stop me from doing my job or something similar to what I'm doing everywhere in the world, no, not enforceable, cannot be enforced. Time period. Rule of thumb, I would say that anything above 6 months is going to be quite difficult to establish. Again, the courts don't really believe that a person should be forced to not work, right? You're entitled to a livelihood, If you have any other interests, confidential information, clients, whatever, can be protected by other ways. Not through a non-compete. It cannot be for the sake of preventing competition. So what is one way around it? And this happens more for our tech clients or for our bigger clients. Pay out to work, or pay out to work, right? You can theoretically pay a person not to work for a competitor for X number of years. After they resign, okay, and that post restrictive covenant or post-contract covenant, restraint of trade covenant is enforceable. Okay, liquidated damages, again, another big issue. I will stress this: a liquidated damages clause is unenforceable if it's a penalty clause. When is it a penalty clause? When it is not a genuine pre-estimate of losses. When it's meant to when it's what we call in terrorem. It basically is to scare you from not breaching a contract. That is unenforceable. Okay, so be very careful when you have these or want to insert these LD clauses. You have to think very hard. Is it a genuine pre-estimate of loss? Am I trying to scare that person into not breaching a contract? What to do when things go wrong? And these are the very standard disputes that we see. Okay, I mean, these are, yeah, I would say a good 90% of disputes tend to be around this area. But generally, these are relatively simple to deal with. Okay, why? Because you can complain MOM. I do, and I would say this, and I'm not saying this because I act for MOM. Okay, I promise you. I'm not saying this just because I act for MOM, but they are very good at what they do, in the sense of, if you report, they actually take it seriously. And their hotline is very good. They will actually give you an answer on the hotline. Can't say the same for all of our regulators or authorities. Again, I act for some of them, I act against some of them. All I'm saying is that MOM is very, very good. They are very good on this. Is it perfect? No. But that's because they are kind of stretched. I'm not going to deny that. Okay. TADAM. TADM or TADAM. This is the Tripartite Alliance for Dispute Management. I would point out a few things. They do offer advisory and mediation services. They are very good at explaining and helping you if you have a dispute with your employer. Right? Again, I've acted for them. So yeah. Okay. I think this can be pretty much my final slide. Why is TADAM important? And the reason why TADAM is important is because you need to go through mediation TADAM before you can start a claim in the Employment Claims Tribunal. So what can they deal with, or what are they allowed to deal with? Salary-related claims, wrongful dismissal claims, and appeals under the retirement and employment contract. Now, if mediation fails, you can go before the Employment Claims Tribunal. One very important thing: it is cheap, it is quick, and no lawyers allowed. Okay, no lawyers allowed. Good and bad. Okay, good and bad. I'm not gonna lie. We know for a fact that some of the bigger firms obviously will engage us. to advise them. We can't appear, but all right. The rest of it, I think I'm just not going into too much detail. I'm just going to say that there are other options available to you if you want to sue in court. One of the limitations of the Employment Claims Tribunal is that it's limited to a $20,000 claim or 30K if you do it through the mediation framework or union dispute. But I would say for most employment disputes in Singapore, you would tend to fall in that. It is because, again, you look at notice period, look at monthly salary. Unless you have a 3-month notice period and you're earning like 10K and above, your realistically your any salary dispute would fall within the employment, the ECT.